All right, so we will go ahead and get started. So good morning, everyone, and welcome to today's webinar, Legal Update with Gov Hutchinson. As you know, October may seem like a long time away, but it'll be here before you know it. And we have the pleasure of having Gov back on October the 13th to go over the long anticipated RPA. So mark that date on your calendar and stay tuned for more information. And now for a more recent update, if you have not done so, be sure to register for 2021 Housing Update with Stephen Thomas and moderated by our president, Nancy Lane, which is scheduled for this Friday. Registrations for all webinars can be found at nsdcrealtors.com/education. So without any further ado, I'm going to turn it over to Gov, and we will go ahead and get started with this morning's presentation. All right, Gov, take it away.
All right. Good morning, everybody. I wish I were there with you in person. I'm sure that will happen again one day, hopefully next year. But we'll do this remotely. As always, early in the year, I talked to you guys about a legal update, the new laws and the new forms that you need to know, because there's always something, right? I mean, sort of the big picture is, if you've noticed, everything ever since COVID started, things just keep changing all the time. And they don't necessarily wait until the end of the year to change. There've just been new developments happening rapidly. And I commend realtors who've been able to adapt and be flexible to all the changes that you've had to deal with. And I'm just going to say you need to be flexible and adapt just a little bit longer. I think we all see the light at the end of the tunnel. Things are going to open up over the next few months, but it's probably going to be different. Things are going to open up at a different pace. Things may be different in different areas compared to other areas. You just have to stay tuned and try to keep up with all the information you receive from the association, from your association, from CAR on all the changes that are happening. But I'll do my best today to sort of bring you up to speed to where we are right now, okay? First of all, as Shirley mentioned, remember in October, I'm going to talk about the new purchase contract. I mean, if you've been around for a while, you've noticed every 5 or 6 or 7 years, there's sort of a major revamp of the purchase contract, and that's due to happen, and it's happening. It's going to happen. It's not going to be released until late December, but starting in September, October, we're going to be doing training classes, and I'm going to be doing one for you guys, as she said, I guess on October 13th. It's not going to be that the form is going to be dramatically changed substantively, but it is going to be different format. So you'll all want to attend that. All right, let's talk about today. What do we want to talk about today? New laws and new forms. First of all, let's start with COVID, just to sort of tell you that nothing has really changed recently. Like I said, it's going to open up, but right now we're still where we've been the last several months. When you show properties, you submit a PED form to the listing agent. These forms have to be kept for 3 years, like other DRE documents. The listing agent has to post the posted rules of entry form at the entrance. One buying party at a time looks at the property. There's not a limit on how many people, as long as they're all part of the same buying party. Everybody wears a mask. If you're not already living together, everybody stands 6 feet apart. You try not to touch anything. Before you get there, the listing agent, opens the doors, turns on the lights, and in between showings, the showing agent wipes down the surfaces, the doorknobs, the handle, the banisters, light switches, sinks, anything that might be touched. You're not supposed to touch it anyway, but nevertheless, it's supposed to be wiped down between each showing. None of that has changed. No open houses, the way we think of open houses. Open to me means you just show up. And there's no just showing up. You make an appointment. Everything today is by appointment only, right? So none of this is really changed. No door knocking. Don't initiate face-to-face contacts with people as far as marketing is concerned. The latest things that have been happening, just to reminding everybody, is you do have you have a responsibility in this era of doing what we call contact tracing, right? What that means is, you have a listing and you're having showings. So people submit the PED form before they get there and they say how they're not sick and everything's good, great. They come into the showing 3 days later, they call you up and say, you know, I just tested, I was in your house 3 days ago and I just tested positive for COVID. Well, now you, the listing agent, have an obligation to make a good faith effort to contact everybody who came into that home during those 3 days since that person was still there, because that's during the infectious period, right? And that's one of the good reasons you have the PED form, okay? The other thing, of course, let's say you have your real estate office. You're allowed to open your real estate office, but let's say people come into your office who don't work there, like clients or agents from other offices or vendors or something. You've got to screen them when they come in. You got to ask them the questions, you know, you've been in contact with anyone who's sick, do you have any symptoms, etc. Please wear a mask. And you keep a record that they were there. You don't have to get a PED form, but you got to keep a record. Because if someone comes into your office and then they call you up 3 days later, say, you know, I just tested, I was in your office a couple of days ago and I just tested positive. You have to make a good faith effort to contact anyone else who came into the office after that sick person did during the infectious period. By the way, what is considered the infectious period? It's actually considered 2 days before you test positive to at least 10 days after you do. Okay. So anyway, there is one brand new thing, brand new law, January 1st, related to this, that is related to work sites. Now, your office is considered a work site. So this is a responsibility for who's ever in charge of the office. If someone who works in the office gets sick, in the real estate case, it would be one of the agents or one of the employees, there's a new requirement that by the end of the next business day, the person in charge of the office, usually in real estate, it would be the broker, must send a written notification to everybody else who works in the office if they were in the office during the sick person's, you know, COVID time, during their infectious period. So in other words, before I was talking about people come to your showings, come to your office, but now I'm talking about the people who actually work in the office. And one of them gets sick, test positive. That's when you have to notify in writing, and there's a special sort of template of what you're supposed to put in this notification. And we have a Q&A on our website called California 685 Notification to Employees About Potential Exposure to COVID-19. And you'll have to, and if it's an employee, you got to tell them what their rights are as far as sick leave and state COVID leave. If it's an independent contractor like an agent, all you have to tell them is basically someone in the office got tested positive and you've been in the office during the infectious period. So you don't tell them who exactly the person is who tested positive. You just tell them that it happened, and you tell them what you're doing as far as cleaning and disinfecting, and it's got to be in writing by the next business day. Okay, we have a form. Well, we have a Q&A that sort of explains, gives you a template of what you actually have to put in this notice if God forbid it ever happens to you. Okay, so that is the latest on the COVID protocols. By the way, if you have any questions, please just put them in the chat and I'll answer them as I go. Don't hesitate to do that. Okay, I'll be able to do that. All right, so that's the latest on COVID rules. That's the latest on the brand new law with that written notification to people who work in the office if someone else in the office gets sick. Okay. By the way, other people ask me questions like, let's say the owner of the property gets test positive for COVID, or the tenant who lives there test positive. Well, obviously you got to tell anyone who wants to come and see the property that the person who lives there is tested positive. And for at least 14 days after they test positive, you need to continue to disclose that. Conservatively, I'd try to even disclose it longer than that, okay? And of course, if one of your agents, obviously, who's out there in the field tests positive, they would have to disclose that on any PED form before they entered the property. And if they do disclose that they currently have it, of course, the owner of the property could say, I don't want that person in my property, obviously, okay? All right. Let's talk about new laws, other new laws that have nothing to do with COVID. And there's a few. There's one really important new law. I'd say it's the most important new law. And that is regarding, there's a new disclosure form called the Home Fire Hardening Disclosure and Advisory Form, HHDA, Home Fire Hardening Disclosure and Advisory. It's kind of a big deal because CAR hasn't had a new disclosure form for like 10 or 15 years. So for the last decade or so, when people ask me, what are the mandatory disclosure forms when I'm selling a house? I always say it's easy to remember like this. Think of NHD plus 4. The NHD report, always order a good NHD report. That covers a lot of things. And then there's 4 other things, right? The TDS, Transfer Disclosure Statement, the SPQ, Seller Property Questionnaire, the lead paint form, FLD, Federal Lead Disclosure, if the house is pre-78. And the 4th one are the 4 booklets, the disclosure book, the earthquake, environmental hazards, home energy, and lead paint booklet. So NHD plus 4. Well, now it's NHD plus 5. There's a 5th mandatory disclosure form, the Home Fire Hardening Disclosure Form. What's different about this form is it's not required on every deal. It's only required if you're selling a house that's in a very high or high fire hazard severity zone, and it was built before 2010. Why is it only required on homes built before 2010? Because homes built after 2010, after January 1st, 2010, in a fire zone, had to be built a certain way so that they were, they couldn't have wood roofs, they had to have dual pane windows, so they're more safe in a fire zone. They make the house more invulnerable to fires, okay? So, but if your house was built before January 1st, 2010, in a fire zone, it might not have the safety features. It might have single pane windows. It may have a wood roof. It may have gutter covers that are combustible material. It may have combustible landscaping within 5 feet of the home. In other words, fire hardening means things you can do to your house to make it safer in the event of a wildfire. What this law says is if you're selling a house to a buyer and you're in a fire zone, you're in an area where there are fires, but the house was built before the updated building code, you got to sort of warn the buyer. So you give them this form, and the form, first of all, tells them what home hardening means, and you're in a fire zone, and maybe you should think about improving your property. Then, of course, the seller has to answer 6 questions. The seller has to disclose on the form if they do have a wood roof, if they do have single pane windows, if they do have rain gutters with combustible rain covers, if they do have landscaping within 5 feet of the house. So they're going to have to disclose to the buyer features of the house that they have that make it less safe than it could be. But that doesn't mean the seller is required to upgrade the house to make it more fire safe. All they have to do is disclose to the buyer certain features that they have. What if the buyer's reaction is, well, I don't like that. I don't like the fact that you have a wood roof. I want a new roof. And the response is, well, I don't want to put a new roof on. So you don't want to buy my house, don't buy my house. It's not a required upgrade, okay? By the way, no, I'm not sharing any screen. It's just me talking, okay? So obviously, every time you take a listing now on residential 1 to 4, you have to figure out if the property you're selling is in a very high or high fire hazard severity zone. And then you have to figure out how old it is. Well, you can probably figure out how old it is, but how do you know if you're in one of these zones? Well, I'll tell you what, if you live in California, there's 4 possibilities. You're either not in a fire zone at all, like me in Culver City, or you're in a moderate fire hazard zone, or you're in a high fire hazard zone, or you're in a very high fire hazard zone. This new disclosure form is only required if you're in a very high or a high. If you're in a moderate, it's not required. And if you're not in any zone at all, you're not required. So the question is, how do I figure out as a listing agent what type of zone I'm in? Well, you look at the NHD report. Remember, the NHD report has 2 fire zones, 2 earthquake zones, 2 flood zones. The 2 fire zones on the NHD report, one of them is very high fire severity zone. That's one of the 2 that triggers this form. So if that box is checked, you know you got to do this form. What if that box isn't checked? Well, there's another box on the NHD called wildland fire areas. If that box is not checked, and the other box isn't checked, you're not in any fire zone, this form isn't required. If that box is checked, the wildland fire zone check, that means you're either in a high or a moderate fire zone. Well, remember the new form is required if you're in a high, but not required if you're in a moderate. Now, I know some people already, they're saying, I don't care, high or moderate, I'm going to give them the form anyway. I think it's a good form. But you don't have to give them the form unless you're in the high as opposed to the moderate. Well, how do I determine if I'm in a high or a moderate? You have to talk to your NHD rep. Your NHD rep will be able to tell you that. And I've noticed some NHD companies are sort of modifying their reports already. So they'll disclose right in the report if you're in a moderate or a high. And they'll also, of course, disclose, a lot of them disclose local fire hazard zones. By the way, if you're in a local fire hazard zone, but not in a state one, that doesn't trigger this form. This form is required now. This came into effect January 1st. So any listing you had after January 1st, you need to give this form to the buyer once you determine if the property's in a very high or high fire zone and it was built before 2010. So let's say you figure that out and you're in the zone. You just pull up the form, the HHDA, and before you give it to the buyer, of course, the seller has to answer those 6 questions. No, Kimberly, if it's moderate, you don't need the form. I'm just saying some realtors I know, some sellers I know, they are providing the form voluntarily, even if it's just in a moderate fire hazard zone as opposed to a high one, but it's not required. It's only required if it's in the state very high or the state high. Okay, I just said you can't tell from the NHD report in its original form. You can tell if it's in a very high, there's a box for that. But if the other box is checked and that one isn't checked, that means moderate or high. You have to go a little bit further research to find out which one you're in. And that's when you talk to your NHD rep and they can tell you whether you're in a high or a moderate. Okay. So once you do it, seller answers the 6 questions and you give the form to the buyer's agent, just like any other disclosure. And it's just like the TDS. When you give it to the buyer's agent, the buyer has a 5-day right to cancel. So obviously you want to give them this form as soon as possible, just like you give the TDS as soon as possible to get rid of the 5-day right of rescission. Some people say, I thought it was 3 to 5 days. Well, it's 3 days if you deliver it in person. I don't think anybody delivers things in person anymore, so just go with 5 days. By the way, sometimes a TDS is not required, right? Probate, REO, bankruptcy sales, sale by a trust. If the trustee has never been on title or has not lived there in the last 12 months, if you're exempt from the TDS, you're exempt from this form. But if you have to do a TDS, you might have to do this form, but only if you're in one of the zones and it was built before 2010. Okay? So it's not required in every sale, but it's required in a lot of sales because a lot of California is in fire zones and you got a lot of properties built before 2010. By the way, there's one other thing on this form. So the form first gives information to the buyer, seller answers 6 questions, and then it says, if the seller has a home fire hardening final inspection report, they should attach it to this disclosure. And people have been asking me, what is a home fire hardening final inspection report? And how do I know if I got one? And my answer is, you know if you got one. But here's what it is. If you're a builder and you built the house, you have one of these things. Or if you're not the builder, but you, the property owner, have made major renovations to this property in this fire zone, then it would have been required that you made your house comply with these home hardening requirements. So even though your house is built before 2010 in the fire zone, let's say you want to do a big renovation, that would probably, depending on when you are, trigger the requirement to do these fire hardening upgrades. And then you would have received this inspection report from the building department, and then you just give it to the buyer. What if you did it, but you never got the report? Then there's nothing you got to give to the buyer. Not your problem. Okay. All right. By the way, give you a little heads up. You know what's coming in July? Another new form regarding defensible space. So this is the home fire hardening form, new form coming out end of June, called the defensible space form. I haven't really seen the final version yet, so I can't really talk about it. Just be aware there's going to be another form that's going to be required also if you're selling in a fire zone regarding the concept of defensible space. So ultimately, there's going to be these two new disclosure forms regarding wildfire zones. This one's in effect right now regarding fire hardening. There's another one coming out end of June regarding defensible space. So starting in July, if you're in one of these fire zones, you're probably going to be providing two new disclosure forms, not just one. Okay? All right. That's the most important new law, and that's the most important new form. All right. What other new laws do I need to know about? Well, there's a few of them, not as crucial as this one. Probably the most important one, and I'm going to cover it quickly. I know you're going to have a property management seminar coming up, but let me just make sure you understand that you probably know this, that the California eviction moratorium was extended from February 1st to July 1st. You know what that means? If someone cannot pay their rent, and the reason they can't pay their rent is COVID, you cannot evict them right now. Now, they still have to pay 25% of the rent, even if they have a COVID reason. If they don't pay if they pay the 25%, you can't evict them ever. They owe you the other 75%, but you can't evict them. If they don't pay the 25%, you can evict them on July 1st. Now, let's say they're not paying the rent, but it's got nothing to do with COVID. You could evict them right now. The moratorium is only on evictions for people who have a COVID reason for not paying. And how do you know they have a COVID reason? Because you gave them a notice to pay or quit, and they responded with a declaration of COVID financial hardship. And you have to take their word for it if they do that. They're saying that under penalty of perjury, criminal offense if they're lying. They're saying that they've got a COVID reason, they can't pay. They still got to pay 25%. Now, starting in July, you can sue them for the back rent. Starting August 1st, you can sue them in small claims court for the back rent, even if it's more than $10,000. But you can't evict them for not paying COVID back rent as long as they pay 25%. Okay? And if you do want to try to evict them, make sure you use the COVID eviction forms. There's no such thing as the normal 3-day notice to pay or quit. It's the COVID 15-day notice, right? And this is going to also last till July. Another thing, what if someone's violating the other terms of the lease? They're not allowing me to show it. They got subtenants without permission. They have pets they shouldn't have. They're causing damage. They're criminal activity. You can evict them right now. But make sure you give them the COVID 3-day notice to cure a covenant or quit. Well, what if I want to kick them out, a tenant out right now, but they didn't do anything wrong? Am I still allowed to evict a tenant for no fault? Well, between now and July 1st, if you want to evict a tenant who's not doing anything wrong, you have to have just cause. And this applies to single family homes, new duplexes, it applies to new construction, it applies to everything. Starting in July, single family homes, owner occupied duplexes, and apartment buildings newer than 15 years will be exempt from all this. But for now, everyone is required to have a just cause reason to evict, which means there's only 4 reasons you have to evict someone now if they didn't do anything wrong. Number 1, you want to move in yourself. You, your parent, grandparent, child, grandchild, or spouse wants to move in. Hey, that's a simple way to get divorced, right? You say to your spouse, honey, you got to move into the rental so we can kick out the tenant. It's nothing personal. Just kidding, right? Just kidding. Okay. Second, you can evict a tenant right now if you have to do a major remodel, but only if the remodel is required and necessary for health and safety reasons. Third reason, you can evict a tenant if you want to get out of the rental business. Maybe you want to just convert the property to commercial space or condominium or something like that. The challenge for that is if you decide to kick out a tenant because you want to take them off the rental market, that means it's got to stay off the rental market for at least 2 years. If you want to put it back on the rental market for within the next 2 years, you got to rent it back to the same tenant you kicked out 2 years ago for the same rent. Fortunately, there's a fourth good reason to evict a tenant that will help you sell the house. And that is, if you're selling a single family house that's tenant occupied and you sell the house, you find a buyer who commits to buy it. They write an offer. On the offer, they say they're going to live there. The seller accepts the offer. As soon as that offer is accepted, you can evict the tenant. In other words, well, obviously you can sell the property with the tenant in there, but you can actually kick the tenant out once you get a buyer who writes an offer that's accepted. In other words, just because you have a listing, you can't evict the tenant. You can't just do a remodel. Oh, I got to kick you out so I can fix up the house before I sell it. That would only work if the remodel was necessary for health and safety reasons. And you can't just kick them out just because you want to take the house off the rental market. Well, that means that doesn't really work for selling, because that means even if you sell the house to the buyer, the house still has to be kept off the rental market for 2 years. That would be restricting the buyer. But that's why it's a good, but as long as you get the buyer who writes an offer that's accepted, then you can give them the notice. How much notice do you have to give? Oh, by the way, yes, I'm assuming there's not a lease. I'm assuming month to month. If there is a lease on the property, you can't do anything to the tenant until the lease is over. All right. Well, how much notice do I have to give a tenant once I have the buyer who's in contract with the seller? Well, assuming once again we're month to month, if the tenant's been there less than a year, 30 days. If they've been there more than a year, 60 days. But even if they've been there more than a year, if the buyer commits on the notice form that they're going to live in the house at least a year, then you could give the tenant only a 30-day notice. So if the buyer just says, yes, I will live in the property, without committing to how long they're going to live there, you would have to give the tenant a 60-day notice if they've been there more than a year. But if the buyer actually commits on the form that they're going to live there more than a year, you only have to give the tenant a 30-day notice, even though they've been there more than a year. All of this, by the way, is explained on these notice forms. But once again, you don't use the normal 60-day notice. You use the COVID notice to terminate tenancy. Okay? All right. Let's talk about some other laws. A couple of other interesting laws. There's a new law regarding homeowners association, HOAs, and their ability to restrict people from renting out their property. Prior to this year, an HOA could have said, nobody can rent out their property here, no rentals. Or they could have said, you can only rent to family members, or you have to live there 3 years before you can rent it out, or only 10% of you can rent it out. Effective January 1st, the law now says HOAs cannot unreasonably restrict someone's ability to rent out the property. So what does unreasonable mean? Well, they've defined it. They said HOAs, the only restriction an HOA can have is they can say no more than 25% of the people who live here can rent out their house or their unit. They can't be stricter than that. Okay, but can they still limit who you rent it to? Well, the question is, is that reasonable? And I guess a judge is going to have to decide that. I guess they could say you can't rent it out to, could they say you can't rent it out to families with children? I would say that violates the fair housing laws. They can't be that restrictive. Maybe they can say you can't rent it out to a heavy metal rock band, right? I mean, that might be a reasonable restriction, but in general, they're not going to be able. They're not going to be able to restrict who you can rent it to. And can they require you to live there for a certain period of time before you rent it out? In my view, that doesn't seem reasonable. But judges will have to decide what's reasonable and what's not. What we know for sure is that they can't say they have to allow at least 25% of the people to rent it out. And by the way, let's say you're renting out a garage, ADU, granny flat. That doesn't count towards the 25%. Okay, so keep that in mind. So good question. Let me go back to some questions here. Brenda, getting back to the rent thing. If a tenant is not paying 25%, you can evict them, but not till July. If they aren't paying if they are paying the 25%, you can never evict them for not paying the other 75. All you can do is sue them for that money. Now, starting in July, assuming this doesn't get extended, if they don't pay the rent in July, no matter what the reason is, you can evict them. But for any rent between last March and next July they couldn't pay because of COVID, you can't use that as a reason to evict them even in July, as long as they pay 25%. Getting back to the questions on the next thing I was talking about, very good questions. Could an HOA restrict the length of a lease agreement, like a minimum of 6 months? That might be reasonable restriction. See, that's the problem. This law says no unreasonable restrictions without defining what's reasonable other than the 25% can rent out. So ultimately, unfortunately, there have to be either regulations or lawsuits to resolve these things. I'm just giving you my best sort of guess. What about a builder with new construction? Can they limit purchasing to non-investors? Yes, they could do that. What about age-restricted communities? Yes, there's special rules for those. Clearly, age-restricted communities can limit on what type of people can live there. Like they could say you can only rent it out to someone over 55 or something like that. And yes, HOAs can still prohibit short-term rentals. 30 days or less, they can say none of that. None of that. But yes, this HOA law, Terry Davis, is all residential property, including single family. A lot of people have a single family house that's part of an HOA, and it's part of that too. Okay, all right. Here's another law. Yes, it is. California law could be described as unfriendly to landlords. You can say that again. By the way, I forgot to mention the good news. There is good news for landlords. Money has been allocated to California to compensate landlords. It's being administered by the Department of HCD, Housing and Community Development. They don't have the program up and running yet, but it's got to be up and running in 3 weeks by March 15th, where certain landlords will be able to apply to HCD for government money to compensate them for the back rent that the tenant owes them. If you qualify, you're going to get this money. And hopefully there's more money. hopefully this 1.9 trillion thing they're talking about in Washington will get passed, which will result in even more money coming to California to compensate landlords. Don't ask me the details because HCD doesn't have the program up yet. Once it's up, we'll let you all know how to apply, okay? By the way, of course, there's going to be a catch. You know what the catch is going to be? The government's going to say, oh, how much does a tenant owe you? $20,000? Okay, we'll give you $16,000 if you forgive the other $4,000. We'll give you 80% if you forgive the other 20%. What if the landlord says, I don't want to forgive anything? Then you're not going to get the money. You have to sue the tenant for all the money. So, you know, details to follow. We don't have all the details. I know you're going to get a good seminar on property management. Hopefully all the details will be available by then. So there'll be more to tell you. Okay. Oh yeah, Shirley, I forgot that you wanted me to stop so you can have a couple of polls. You want me to stop, Shirley, or just let him answer the question? Shirley, you're muted. You're muted.
You can continue, and
Okay.
I'll just leave the poll for a minute or so.
Okay. So Shirley put a poll in there, so please answer the poll, but I'll keep going. All right. Dana, can an age-restricted community restrict children if the restrictions in the CC&Rs? Yes, if it's an age-restricted community, they are allowed to restrict children, whereas a normal, non-age restricted community wouldn't be able to do that. Another good question. Yes, if the landlord won't accept the 80% that they're being offered, the tenant can then apply for the 25%. So if landlord doesn't want the 80% because they don't want to forgive the other 20%, then the tenant can separately apply for 25% to cover their 25%. All right, let's talk about another new law. You're going to love this one. There's a significant change in foreclosures. So let's say you got a property house in foreclosure. So there's an auction scheduled, and you show up at the auction and you make a bid and you win the auction. So now it's your property, right? Not so fast. If you foreclosed on a residential property occupied by a tenant, the tenant has 15 days after the foreclosure auction sale to submit to notify the trustee that they want to buy it instead of the person who just won the auction. They want to buy it for that same price that was the winning price at the auction. If they submit this within 15 days, then they have a total of 45 days dating back to the date of the auction. If they can come up with the money, then they can buy the property. So the person who thought they got the property when they won the auction, they don't get it anymore. Unless the person who won the auction plans to live there. So if you foreclose, if you win and you want to live there, it's yours. But if it's a foreclosure by an investor, and there's a tenant on there, this is residential, commercial, same old rule. That's the old rules. Residential, there's a tenant there. The tenant indicates within 15 days after the foreclosure that they want it. They submit that in 15 days, then they have an additional 30 days to come up with the money. If they can't come up with the money, too bad. 45 days later, you get it. But guess what? Even if there's not a tenant on the property, or there's a tenant there, but they're not going to try to buy it. If the person who forecloses on the residential property does not intend to live there, then anyone in California who wants to live in that house can submit a bid to the trustee within 15 days after the foreclosure sale. And the bid, of course, has to be higher than the bid that won at the auction. So, of course, you'd be thinking, if they want the house, why didn't they go to the auction? Why did they wait till after the auction? Because now they got a bid higher than that. Nevertheless, if they do submit a bid within 15 days, assuming there's no tenant, they submit a prospective owner-occupant or certain nonprofit housing providers. If they submit a bid within 15 days that's higher than the price, and they'll be able to go to the trustee's website to see what the winning bid was. If they submit a bid within 15 days and they can actually come up with the money by 45 days, they get the property rather than the person who won it at the auction. That's assuming the person who won at the auction is an investor. Bottom line is now, when you foreclose on a residential property and you're an investor, you don't really know if it's yours for about 45 days or maybe 15. If there's no bid submitted within 15, okay. But if there's a bid submitted, you don't know until the 45th day whether they're actually going to buy the house. Okay. There probably is a way you can find homes that were recently bought by auction. Remember, you only have 15 days to do this after the auction. And I'm not the best person to figure out how to get that list, but I'm sure there's a way to get that list. Okay, let's talk about another new law. I got some good news for you. The good news is everybody in California has an increase in their homestead amount. What is your homestead amount? When you own a primary residence, the homestead amount is the amount of protection you have against an unsecured creditor foreclosing on your house. Okay, I'll explain how that works. Prior to this year, the amount of homestead you had on your house was, depending on who you were. If you were single, $75,000. If you were head of a household of at least 2 people, it was $100,000. If you were over 65 or over 55 and disabled, it was $175,000. So let's say me last year, I'm a head of a household, I'm not 65, so I had a $100,000 homestead. Now let's say on my mortgage, I owe about $150,000. Someone sued me and got a judgment against me for $250,000. They could not touch my house because they wouldn't have enough money to pay off my $150,000 mortgage and pay me my $100,000. But let's say they sued me for $500,000 and they won. Now they could have foreclosed on my house, paid off my lender $150,000, given me my $100,000, and they keep the rest. Well, this year they couldn't do that because my homestead is no longer $100,000. My homestead is now $600,000. Here's the deal. Everyone's homestead on your primary residence in California now is either $300,000 or the median sales price of a single family home in your county the previous year with a cap of $600,000. So in LA County, where I live, the median sales price last year was over $600,000, which means the homestead amount for everyone everyone owns a house or condo or mobile home in LA County is $600,000. So let's say I owe my lender $150,000. That's a total of $750,000. Someone got a judgment against me for $700,000. They couldn't touch my house because they don't have enough to pay off my loan and pay me my $600,000. So what is your homestead amount in San Diego County? I don't know. Do any of you know offhand what the median sales price of a single family home was in San Diego County last year? If you do, put it in the chat. So you're just a guess. You're not committed to this, Do anyone know, was it less than 600,000? Whatever it was, if it was less than 600,000, that's everyone's homestead amount. Regardless of marital status, regardless of anything. You own the house, it's your primary residence, you have this protection. Now, very good, next question, very good question is, do I have to record a declaration of homestead, or is this automatic? Number one, this protection I just described is automatic, but I recommend that everybody records a declaration of homestead, because by doing that, you get even more protection. If you record a declaration of homestead, not only are you protected from someone foreclosing on you, you can actually voluntarily sell the house, and the judgment against you doesn't attach to the proceeds as long as you reinvest those proceeds in another house within 6 months. So you see what I'm saying? It's good. And no, I don't think there's any negative to recording a homestead. So, but even if you don't record it, you still get the basic protection I just described. Okay. Wow, John, thank you. It looks like median sales price was $650, which means that everyone in San Diego County has a $600,000 homestead on your house. So that's good news. All right. What else is going on? Another big thing, of course, is Prop 19. It's sort of a new law. It's a proposition. Yes, this is only for your primary residence, the homestead. Okay. So, what is Prop 19? Well, Prop 19 has expanded the ability of us property owners, especially people like me over 55, who I can sell my current property and move to another property and take the low property tax I'm paying on my current property to the new property. Now, we've already got current law, which is something called Prop 60, Prop 90, which says right now, if you're over 55 or severely disabled, you can sell your primary residence and move to another one and take your property tax with you, as long as you're in LA County, Orange County, Ventura County, San Diego County, Riverside, or San Bernardino. You can move within your county or into one of those counties. And the new house has to be cheaper than the old house. But if that's the case, you can do it right now. You can transfer your property tax. Prop 19, which takes effect April 1st, expands that. It says, first of all, you can do this if you're over 55, severely disabled, or the victim of a wildfire. That's the first change. The second change is you can do this 3 times. Under existing law, you can only do this once. So even if you've already done it, you're over 55, you already did it you can do it again 3 more times. The third new thing is you don't have to stay in Southern California. You could sell your house here and move anywhere in California and transfer your property tax basis with you. And most importantly, under this new Prop 19, you can sell your existing house and buy a replacement property that costs more than your existing house and still transfer the property tax that you're paying on your current house to the new house with a minor adjustment. I'll give you an example. Let's say you bought a house in San Diego County a long time ago for like $200,000. It's now worth $1 million. But you're paying property tax based on $200,000. But you want to move. Well, as long as you stay in Southern California, the areas I mentioned, as long as you buy a new house for less than $1 million, you transfer the 200,000 tax basis to the new house. But let's say I want to buy a more expensive house, or I don't want to stay in Southern California, or I've already done it before, I want to do it again. Well, let's say your house is worth $1 million and you want to buy another one that costs 1.1. What's the property tax basis going to be on that property? Well, it's going to be the 200,000 on your current home, plus the difference between the purchase price of the new one and the sales price of the old one, which is 1.1 million minus $1 million, that's 100,000. So your property tax basis under Prop 19 on the new 1.1 million house is going to be 200 plus 100, 300,000, as opposed to 1.1 million. In other words, even if you're buying a more expensive house, there's a very good benefit to doing it. The only question is the effective date of this. I mean, the effective date is April 1st. Does that mean I got to wait till April 1st to sell my existing house and buy the new one? Or can I sell my existing house first before April 1st and then just transfer the property tax basis on April 1st, right? So that's, unbelievably or not, we still don't have an answer to that question. The proposition doesn't make that clear. And the assessors are saying we need legislation to make that clear. So we're working on that. We're pushing it. We're trying to make it happen. Of course, we're already towards the end of February. But the point is, people asking me, I sold my house back in January, and now I want to buy a new one that's more expensive. Can I transfer the property tax from the one I sold in January to the new one? Or is the fact that I closed the old one prior to April 1st going to stop me from doing that? We hope that even though you sold the old one before April 1st, you can transfer the property tax base to the new one after April 1st. But we don't know that for sure, and you can't tell your clients that. So obviously the safe thing to do is wait, don't close either side until April 1st. By the way, you can buy the replacement property before you sell the original property. The question is to take advantage of these expanded Prop 19 rights. Do I have to do the actual transaction close after April 1st? Or can I just do the transfer of the tax basis after April 1st? As soon as we get an answer, you'll get the answer from us. But that's the way it is right now. Okay. All right. By the way, there is bad news in Prop 19, but people start complaining about it, and I say, well, you really shouldn't complain. I'll tell you what. I'll tell you why. Normally, as you know, when you transfer property from one person to another, it gets reassessed. But there are some exceptions to that. One of the exceptions for the last, I forget how many years, is Sandy Adelson. If the San Diego assessor said that, yeah, they're saying if the transaction's after April 1st. Of course, my comment is, what if one of the transactions was before April 1st? Will they still allow you to transfer it? And it's possible that will be the case. But yes, as long as the transaction's after April 1st, unless, Sandy, are you saying that they're saying as long as one of the transactions is after April 1st? That would be good news. Anyway, let's get back to what I was saying. Normally, when you transfer property from one person to another, either while you're alive or through your will, it gets reassessed. But there's been an exception for the last, I forget how many years, that a transfer between generations, a transfer from a parent to a child or a grandparent to a grandchild, did not trigger reassessment. So, and that was for primary transfer of a primary residence and $1 million worth of other real estate. Well, that's gone now. That was gone February 16th. Now, the only intergenerational transfer that doesn't trigger reassessment is a transfer of a primary residence, but the recipient has to also use it as a primary residence. You see what I'm saying? So that's a change. That's not a good change. But the thing of it, when people start complaining, I say, the legislature before Prop 19 was already moving towards eliminating the intergenerational transfer exemption from property tax reassessment. I'm 99% sure it was going to happen. So if you look at it that way, at least Prop 19 preserved that you can still transfer a primary residence to your heirs without reassessment, but the catch is they got to use it themselves as a primary residence. Okay, see what I mean? So anyway, that's Prop 19. We'll let you know. So a couple of things you're waiting to hear, right? You're waiting to hear from the Department of HCD how to apply for rental assistance if you're a landlord owed back COVID rent. We're also waiting to see about the Prop 19, whether I can make this transfer of property tax basis even if one of or both of the transactions occurred prior to April 1st. So as soon as we get those answers, we will let everybody know. Nicholas, unfortunately, if the recipient takes the primary residence as a primary residence, but then a year later turns it into a rental, it'll get reassessed a year later. In other words, they got to live in it indefinitely. Once they stop living it as their primary residence, it will get reassessed. Okay, so I said this isn't the greatest, but that's the way it is. We got another poll. Everyone, please answer that. And I'm almost done anyway. Those, I believe, are the only really important new laws you should know about. How about new forms? Okay. The only new forms you really got to know about. Number one, I told you the home fire hardening disclosure. If you're selling residential 1 to 4 in a very high or high fire zone, and the property was built before 2010. New form number 2, it's not really a form, but remember I mentioned right at the beginning, if at your office someone tests positive for COVID, in the office, you must, by the end of the next business day, notify in writing in a particular format, not a form, but a particular format, everyone else who works in the office that this happened. Please get our Q&A called California AB 685 to give you the format. There's a third new form I did not mention yet, but regarding the extension of the eviction moratorium, any landlord in California, residential, who has a tenant who owes them back rent for COVID, if you want to preserve your right to be able to get that money from the tenant, you must give to the tenant by the end of February a new form called the NTRA 2, Notice of Tenant Relief Act 2, to distinguish it from the NTRA, the original one came out a year ago. Even if you gave the original one to the tenant last year, you have to give a new form to your tenant this year by the end of this week if they owe you back rent based on COVID. What if I don't do it by February 28th? It's not crystal clear what that means, but you might have problems evicting them in July, even though they haven't been paying the 25%. You want to preserve your rights to be able to evict. So please, if you're a landlord and you have tenants who owe you COVID back rent, please give them the NTRA 2. So those are the real forms you got to know about. The mandatory home fire hardening advisory, the mandatory NTRA 2, and the third one, not really a form so much as a it's a format, a template to notify people in your office if someone gets sick. And those are the really only new forms. The other form that came out, remember the defensible space form is coming out in July. And the other new form is, you've already noticed this one. It's been out since October. You know, the Fair Housing Advisory. And you notice that's attached to your listing. It's attached to the purchase contract. It's attached to the buyer broker contracts. It's attached to the residential lease form. If you have that form, make sure your client signs it. That protects you from the client saying, well, you never told me about the fair housing laws. You never told me I couldn't discriminate against people with children or something like that. And say, yeah, I gave you the form and you signed it. So I told you what you needed to know. Okay. All right. To finish this up, Robin, Prop 19, if you've already done a Prop 60 or Prop 90 in the past, no, that doesn't count as one of the 3 you can do under Prop 19. So you got 3 more. Very good question. All right, Shirley, it's 11 o'clock and I don't think I see any more questions. Yes, there is still a step-up basis at death capital gains tax. Yes, there's still capital gains. You still get that benefit, but you don't get the property tax reassessment benefit. Very good. You're welcome, everybody. Okay, Shirley. You're still muted, Shirley. Shirley,
thank you so much, Gov. We really appreciate it.
My pleasure. I'll see you soon.
All right. All right. See you in October.
Yes, see you then. Okay.
All right.
Bye,
Bye-bye.
everybody. Thanks for coming. Bye-bye.